Hi everyone, I'm Breanna Redhead, and today I'm going to be talking about defamation and exploring what that is, as well as the steps involved in starting a defamation case. So to begin, I'm going to be providing a definition on what defamation is, as well as a little bit of background information, and I'll also be defining some other key terms that are associated with the topic. After that, I'll be looking at how a defamation case is conducted and the steps involved in getting a defamation case to the court. Then we will be looking at some examples of defamation right here in Australia, before finishing up with some ethical issues that are commonly involved in defamation and how it can be avoided. So, what is defamation? Our textbook defines defamation as the wrong of injuring another's reputation without good reason or justification. Defamation is the most common form of litigation for writers, so I do think that it is important that we understand what it is and how it can be avoided. The official Australian Defamation Act was introduced in 2005, and before then every state and territory in Australia had their own laws regarding defamation, but governmental pressure saw the remodelling of the laws, allowing for a more uniform code that was followed across the nation by every single state and territory. That being said, there are still a few little tiny minor differences in the Act, most noticeably being the removal of juries in civil cases in South Australia, the ACT and the Northern Territory, as well as in the Federal Court. Now, within the jurisdiction, defamation comes under the ruling of tort, and tort is most commonly known as the civil wrongdoing, which refers to the suffering or harm of the claimant. Now, this can include physical or emotional distress, negligence, invasion of privacy, or financial loss. In some cases, defamation can be justified if there is enough legal evidence to establish defence. However, the consequences for a guilty charge of defamation can be incredibly severe, from the mere removal of the article to the closing of the website or company that produced the article, and even jail time. Some other phrases I will refer to throughout this presentation are the plaintiff, which is the person bringing the case to the court who believes their reputation has been damaged; imputation, which is the defamatory meaning conveyed in the identified evidence; and the limitation period, which is the period of time an individual is able to file for a defamation case. Here in Australia, it is a time frame of 1 year from the date the article was published. In the case of online material, that limitation period is renewed every single time the article is downloaded, which therefore allows for a much longer lifespan of that article than a print article. There have been a few cases, of course, outside of this time period that have gone to the court, but that is because the reasoning and the evidence presented was justified. Now, when bringing a defamation case to the court, there are 3 elements that you must provide for the case to be deemed worthy of court judgment. These are defamatory matter, identification, and publication. Such elements help identify cases that are, firstly, legitimate cases of defamation, and secondly, cases that require discussion in the court to determine an outcome. To help better recognise these elements, I'll be referring to the 2019 defamation case between Geoffrey Rush and Nationwide News. Now, Geoffrey Rush is an Oscar award-winning Australian actor who is best known for his roles in The Book Thief, The King's Speech, and the Pirates of the Caribbean franchise. In 2015, Rush performed in the titular role of the Sydney Theatre Company's production of the Shakespearean classic King Lear. The Daily Telegraph, which is a subsidiary of Rupert Murdoch's Nationwide News, allegedly produced a variety of articles highlighting Rush's engagement in inappropriate behaviour, both throughout the rehearsal period and backstage during the performances of the show. They named Rush's co-star Erin Jean Norval as a star witness. So the first element here is defamatory matter, which comes under Section 4 of the Defamation Act and refers to the variety of published materials that can be used to damage someone else's reputation. The full list is here on the screen, and you can see that it refers to everything from print news, articles, opinion columns, to television reports, radio reports, online material, which can be emails, text messages, images, anything, and even things like word of mouth, oral utterances, photographs, and even physical actions of an individual. So there's a really broad range there of things that do classify as defamatory matter. But looking at Rush's case in particular, the defamatory matter in question would be the newspaper articles published in the Daily Telegraph, which is outlined in point A of Section 4 there on the screen. So once this defamatory matter has been recognised, The second element is identification. And in defamation, identification refers to the plaintiff being able to prove that the presented defamatory matter is in fact referring to them. And to determine this, the jury are advised to find an ordinary person with reasonable knowledge in the circumstances to view the evidence and decide for themselves whether or not they think it is referring to the person in question. Taking Rush's case as an example, he identified a variety of articles in the Daily Telegraph with headlines including Star's Bad Behaviour and King Lear, spelt ER, along with a sensationalized front page image, to be giving the imputation of him as a sexual predator and therefore damaging his reputation. So the jury found someone within the paper's demographic and with socially conservative views to read the articles and decide whether they were in fact referring to Geoffrey Rush. The reason they do this is because they believe an individual who is considered to be an ordinary individual is less intelligent and has a more conversational knowledge. Therefore, their ability to identify evidence as referring to a specific person therefore pinpoints it as definitely being about that person. In some cases, like the one here, it is very easy to identify the person as they are named, or in this case even photographed in the articles. However, sometimes it is more referred to between the lines. So say for example there was a story written about a bank robbery saying that $1 million was stolen last Monday, and then it also continued to say that the manager of the bank had taken time off since last Monday. It is very clear that the bank manager is implied to be the one who took the money. In America, the plaintiff must prove the ways in which these imputations are false. However, here in Australia, the identification decided by that ordinary individual is considered to be enough. So as you can see, identification is a very important step in conducting defamation, as it separates those legitimate cases from cases that are just trying to get some kind of compensation from a random article that does not even concern them. The final element is publication, which is commonly referred to as publication to the third party. Similar to identification, this element ensures the audience reach of the defamatory material in question, demonstrating that it has been published to a wider audience other than just the plaintiff and the respondent. Looking again at Geoffrey Rush's case, the articles were found in the Daily Telegraph, which is a New South Wales statewide publication that boasts itself as the #1 newspaper in New South Wales. Not only this, but the company also publishes online and also has a mobile app with a total combined monthly reach of approximately 4.3 million people, which is very clearly a lot more than just the two parties named. Had this publication not reached a third party, the case would have just been dismissed, as it is believed that no one else was there to witness the defamatory material. So say for example that I made a defamatory comment to my friend, she couldn't sue me as there was no one else around to witness it happen. Similarly, if I made that comment and that person then went and told her friend about what had happened, I still couldn't be sued as the author of the defamatory material has changed from myself to her. However, if I made a defamatory statement and then sent a text message to one of my other friends explaining what had happened and what I had said, I could be sued for defamation, as that information has been spread to a third person that was not directly involved in the scenario and therefore is considered to be a witness. Looking at these three steps altogether, I don't really think that one is more important than the other. Of course, that being said, without defamatory matter, you can't really have a defamation case, as there is no imputation and no material that is damaging someone else's reputation. But looking at identification and publication, I do believe they are both equally important to one another, as they both contribute to recognising the impact and legitimacy of a case. The outcome of Geoffrey Rush's case found Nationwide News to be guilty, and all the relevant articles were removed. They were also required to pay a compensation for any damages, which came to $850,000, and then further for any economic loss that Rush suffered, which in the end totaled to approximately $2.3 million. So therefore, you can see the importance of that limitation period, because despite the events of this case occurring in 2015, it has taken 4 years for a final outcome to be reached. So looking at a different case now, this one is a lot smaller than the other one in terms of media coverage, and it happened just last month, and it is the Victorian Legal Service Commission, the VLSC, versus Adam Priddle of Priddle Legal Practice in Victoria. In a brief summary, the VLSC was charging Mr. Priddle of 3 counts of legal misconduct after he had been found not returning documents and files to clients after his employment with them had ceased, and further, he was found threatening these clients, which is breaking parts of the Legal Progression Uniform Code. So looking at the 3 steps here in this case, the defamatory matter is a little bit different to the previous one, as it is a series of emails as opposed to newspaper articles, as well as the physical actions conducted by Mr. Priddle. Some notable quotes drawn from Mr. Priddle's emails are found here on the screen. These are emails to the VLSC, and it is clear that both these quotes display threatening and aggressive language, as well as cases of bribery. So even further, emails to Mrs. N, who was a client in this case, showed similar actions, and this of course is not condoned by the VLSC, and therefore in doing so Mr. Priddle is damaging their reputation, therefore causing defamation. So the identification in this case is very simple, as the emails and actions were sent to the VLSC and the actions carried out abuse their protocols that legal practices and lawyers across all of Victoria are required to follow, very similar to the code of ethics that we follow as journalists. Similarly, the publication is also very easily recognised in this case, as the articles were spread to Mr. B and Mrs. N, who are 2 parties that are neither the accused or the applicant. Therefore, they are recognised as third parties that are outside the directly involved, and the case is considered to be spread wide enough to cause defamation. And now, even though this case didn't reach as many as the 4.3 million people of the previous case, you can see that as long as it is someone outside of the 2 people directly involved, it is considered to be damaging to someone's reputation. Now, as this case was significantly smaller than the previous one, the charges were not as drastic. The VLSC did win the case, and Adam Priddle was reprimanded for his actions and required to pay a fee of $3,000 to cover the fees and disbursements of the VLSC. So once again, we see the plaintiff we see the guilty having to compensate for the damages of the plaintiff, although in this case it was just a significantly smaller amount than the last one. So finishing up looking at some ethical issues around defamation, there actually isn't any, because defamation itself is what is considered to be the ethical issue that a lot of journalists, media, and even, as we've just seen, ordinary people find themselves crossing. But however, I do think it is important that we look into the ways in which defamation can be avoided. As with any court ruling, there are defences against defamation that justify the actions of the writer and the content of the material they have produced. Chapter 8 of our textbook covers a variety of these defences really quite thoroughly. And some of these defences include justification of the truth, which is where the writer must prove the truth and authenticity behind what they have written. As I previously mentioned, this is the opposite. So in the US, the plaintiff is required to prove the falseness, whereas here in Australia, the writer is told they have to prove the truth of whatever it is they have written, if it is in fact true. And that doesn't matter whether it's substantial truth or contextual truth. If they have evidence of it being true, they are required to prove that to the court. The second defence is, of course, public interest, which includes fair reporting, honest opinion, qualified privilege, and political discussion, which comes back to that utilitarian virtue of providing the greatest happiness for the greatest number. And the last defence is triviality, which means that the context of the material was disseminated innocently and is too sarcastic or ridiculous to be of any concern in actually damaging someone's reputation. Overall, the best advice offered to journalists is the same as it always has been, and that is to remain objective and not implement any sort of bias in your writing, which is where a lot of defamation does stem from. So ultimately, if it doesn't really feel right, you probably shouldn't do it, and you should stick to what we were always told as children, which is that if you don't have anything nice to say, don't say anything at all, unless, of course, it is true. Thank you.